So what is bankruptcy and how does it really work? Well, bankruptcy is a legal tool to obtain debt relief and get a fresh financial start. As a matter of fact, the right to file for bankruptcy protection is a constitutional right. Article 1, Section 8 of the United States Constitution authorizes Congress to enact uniform laws on the subject of bankruptcies. Under this grant of authority, Congress enacted the Bankruptcy Code in 1978. The Bankruptcy Code has been amended several times since its enactment. It is the uniform federal law that governs all bankruptcy cases. There is a bankruptcy court for each judicial district in the country. Each state has one or more districts. There are 90 bankruptcy districts across the country. The bankruptcy courts generally have their own clerk's offices to process bankruptcy cases. Here in Georgia, we have 3 bankruptcy districts: the Northern District of Georgia, the Middle District of Georgia, and finally, the Southern District of Georgia. Our firm practices in the Northern and Middle. The court official with decision-making power over federal bankruptcy cases is the United States Bankruptcy Judge. The Bankruptcy Judge may decide any matter connected with the bankruptcy case, such as eligibility to file or whether a debtor should even receive a discharge of their debts. Much of the bankruptcy process, however, is administrative, and this will be conducted away from the courthouse. In most consumer cases, that's Chapter 7 or 13, the administrative process is carried out by someone called a trustee, who is appointed to oversee the case. A debtor's involvement with the bankruptcy judge is usually very, very limited. Most folks never see their judge, as a matter of fact. And that's a good thing. Usually, though, the only formal proceeding at which a debtor must appear is the Meeting of Creditors. And that's usually held at an office in the federal building. But of course, right now, due to COVID, we're doing all hearings by phone. So that's a nice thing for folks that are thinking about bankruptcy, is they actually don't have to physically go for a court hearing. But this hearing is called the 341 Meeting of Creditors because 341 of the Bankruptcy Code requires that a debtor attend this meeting so that creditors can question the debtor about the debts and property, although most of the time the creditors don't show up. A fundamental goal of the federal bankruptcy laws enacted by Congress is to give debtors a fresh financial start from burdensome debts. Our legislators realize that if someone is being crushed with debt, it is very difficult to move forward. Consumer bankruptcy cases work like this. You schedule a meeting with an attorney, a bankruptcy attorney, to review all of your debts, assets, and income. The attorney will then analyze this information and provide options as to which chapter 7 or 13, you qualify for and what are the consequences of each. If you decide to move forward, the attorney will provide you with your bankruptcy petition and schedules to review, and then once you sign these, your case will be filed with the court. In about 30 to 45 days, you have your hearing, and if you are in a Chapter 7 case, you are just waiting for your discharge after that. And if you're in a Chapter 13 case, you have another 30 days to cure any objections the trustee has stated. By the way, they always have objections, but if you have a good attorney, they'll resolve them for you. After 30 days, your case is reviewed again by the trustee for case approval. Bankruptcy is probably one of the most misunderstood areas of the law, and I would encourage you to meet with a bankruptcy attorney to see what your options are. Too many times I see people obsessed with their credit, and even though they are drowning in debt and cannot do anything, they cannot bear to see their credit score take a hit, even though they cannot save for a rainy day, take a vacation, or even put a dent in their current debt load. Yes, filing bankruptcy will hit your credit score. But the good news is, in about 12 months, most people have their score back to a good score. If you really want to see how fast people rebound from bankruptcy, take a look at any mortgage requirement sheet. Go to any of the big lenders' websites. They almost all say they will provide you a mortgage after 24 months discharged from a bankruptcy case. For most people who are drowning in debt, 24 months is not a long time to wait to rebuild your credit. And buy a home. Another thing you also have to keep in mind is that when you do debt settlement and debt consolidation, that hurts your credit as well. So your credit's still going to take a hit. Everyone's case is different, but you really need to run the numbers and see where you will be in 24 months with the debt repayment or debt wipeout plan you are in. Our firm offers free consultations, which are 100% confidential. We do video, we do phone, in person. We counsel business owners in every range of occupation you can think about debt issues and ways to resolve them. Our attorneys always provide options, and we don't try to push someone into a path. At the end of the day, that is your choice, and since you are the one that has to live with this, you've got to pick your path. If you have any questions about bankruptcy or would like any more information about the process, please don't hesitate to reach out to me. I'm always happy to review your specific situation and provide you with an option plan. And sometimes those option plans are non-bankruptcy options, but find out what's available to you.